who will be Paul Hetznecker, who I've known for a while as an attorney. And what it says here is that Paul is a civil rights and criminal defense attorney who has represented numerous activists. Well, that's like saying Thurgood Marshall was a judge who was involved in some cases and handled some clients as a lawyer. Paul has done much more than represented numerous activists, and maybe we'll get a chance to talk to you about that, but for the most part, he's going to talk about the history of spying on activists, especially in Philadelphia. Let's give Paul a big round of applause.
Thank you. It's certainly an honor and pleasure to be here. I have a tremendous amount of information that I want to impart, most of which I can't do so in a small, limited period of time. But I do want to put some of what has happened and has been revealed over the last few months in a historical context. Obviously, those of you who are aware and have some sense of history in this country are aware that the War on Dissent has a long and storied history in this country. And I refer back to the programs during the 60s and 70s, the COINTEL program run by the FBI, counterintelligence program, which was a program initiated by the federal government to infiltrate, to conduct surveillance, to spy upon, to disrupt and harass activists in this country, both in the civil rights movement and the anti-war movement. That coincided with programs run by the Department of Defense as well as the CIA. The Department of Defense had a program called CONUS, and the CIA ran a program called Chaos, which was really an umbrella for a lot of illegal domestic spying that was going on in this country. Following the revelation of the illegal conduct by this federal government in spying on its own citizens, the Church Committee hearings in the 70s, many of you are aware of those and may recall them, revealed much of what was not known by the public. And out of those revelations, there was legislation, and one of the important pieces of legislation really divided the notion of international spying through the NSA and domestic gathering of intelligence. And it divided and gave responsibilities to various organizations within the federal government to do that or not to do it. Prohibited certain organizations, such as the CIA, the Defense Intelligence Agency, from conducting domestic spying, with some caveats. We know now that after 9/11, much of that was obliterated. In fact, the Patriot Act did much to codify what had already been being done illegally by the federal government in terms of its investigation and surveillance of activists in this country nationwide. And I harken back to a time in the early 80s when there was a very strong anti-interventionist movement in this country, anti-interventionist in Central America, that we did not want the Reagan administration colonializing El Salvador and Nicaragua to the extent that they had done the rest of Latin America. So there was a great upswell of support. In fact, I remember as a young activist, before I became a lawyer, attending many demonstrations in Philadelphia throughout the region in opposition to the Reagan's war, covert war in Central America. Well, at the same time there was this upswell of opposition to American foreign policy in Central America, there was also a slumbering giant of intelligence gathering going on. And one of the apparatuses that was used was a coalition of right-wing think tanks that would provide intelligence to the federal government agencies. And much like ITRR has done here, stir up information, much of which was not true, exaggerated, embellished, based on the idea that there was a swell of communists in this country, and then they were imbuing the ranks of the anti-interventionist movement and anti-apartheid movement, and therefore there should be a catalog, a national catalog of dissenters. Now we know from COINTELPRO that the federal government had been doing that for years, that there would be dossiers on people, and much to the chagrin of the federal government, there were successful lawsuits which revealed a lot of this information, one by the National Lawyers Guild, regarding the intelligence gathering that was done by the national government. Now, I'm going to quickly move through this because, as I said, there's a massive amount of information and I've got to condense it. One of the organizations, one of the right-wing think tanks, was the Malden Institute, sponsored by Richard Mellon Scaife, who was a billionaire right-wing, I guess he's the heir to the Mellon Bank fortune, based in Pittsburgh, and he sponsored the establishment of the Malden Institute. It became relevant to me when I was representing the Republican National Convention protesters in 2000. What we saw during that time period, 10 years ago, was that this emerging sleeping giant was now no longer slumbering, that it was willing to flex its muscles in open air and intimidate individuals who had dared to come to Philadelphia to protest the coronation of George Bush. And they did so in a pattern that has been repeated over and over again since every election. And I'll run through the pattern real quickly, and I'll talk about why ITRR is so dangerous in terms of this melding of private and public intelligence gathering. What they did was very simple. Following the WTO protests in Seattle in 1999, the federal government decided to embolden the Federal Terrorism Task Force and use federal resources and local resources and create a national intelligence gathering such that they would use local police departments, much like they had done in the 60s with the Red Squads, but in a much more sophisticated manner. And in anticipation of the Republican National Convention, a plan which we found out after the fact when we were representing many of the activists, and I also participated in the lawsuit in representing the individuals who were arrested in a measure of preventive detention in the puppet space in West Philadelphia, which is a story in and of itself. But what was essentially happening was that there would be squads of agents that would go throughout this country, go to known activists or people who were labeled as leaders and organizers, knock on their doors and try to scare them, try to intimidate them. Intimidate them at their places of employment, intimidate them when they went to their families, their homes. And that was one first measure of this activity. The second was to start to troll the internet. And not only troll the internet, but before the establishment of the Patriot Act, which allows for roving warrants, they were gathering information on the internet. Intelligence, political intelligence gathering, is a very clear example of this war on dissent, in order to effectively nullify the, quote, organizational leaders of the protests prior to August 4th, 2000, which was when the convention kicked off. So what they did was they started monitoring cell phones. They monitored individuals. They had a whole group of people that they believed to be the leadership of this organizational effort in Philadelphia for, in opposition to George Bush's coronation, and they started plucking people off the street. That's what they did. All under our noses. And it wasn't so blatantly clear until we started doing the criminal cases and getting discovery in these cases, and it was revealed how extensive it was. In 1987, in a demonstration that I participated as a young law student, down in celebration of the bicentennial of the Constitution, there was a number of arrests of activists on the scene, and I was the National Lawyers Guild legal representative there on the scene, trying to negotiate with the FBI and Park Service where people could stand and exercise their First Amendment rights without getting arrested. Unbeknownst to me, they of course changed the police barricades and against our agreement and arrested several activists. Out of the lawsuit that was brought by the ACLU, there was a prohibition against infiltration by the Philadelphia Police Department into organizations, protest organizations in Philadelphia. It was an injunction, it was an agreement reached by the plaintiffs in the city of Philadelphia. Fast forward to 2000, the way the FBI Terrorism Task Force, which incorporated the state police and local agencies, the way they got around that and infiltrated the public space of protesters is was they used the state police. So if we're looking at the state police as a guardian of our civil liberties on this effort to exclude ITRR and now give into the state police the hands of this intelligence gathering, they've been doing it already. And they got around the civil injunction that was imposed 10 years before, in 2000, by infiltrating the public space and the protesters there. To what end? To what end? To stifle dissent. To undermine our First Amendment rights. That's essentially it. In the quest, or in the notion that we are somehow investigating terrorism and national security threats, we have now incorporated every protest group, everyone who raises a voice in dissent or opposition to the powers that be in this country are now labeled a national security threat, and therefore subject to cataloging and dossier creating. That's what we're facing in this country, and it's been here for a long time. So while ITRR and the revelation of this private-public interface of intelligence gathering emerged 3 months ago, it has been going on consistently for decades. Harken back to the Malden Institute. What happened during this development of information by the FBI Terrorism Task Force and its local agencies, state police, etc., was they used the Malden Institute information about protesters that were coming to Philadelphia. The Malden Institute was contracted to gather political intelligence for federal agencies, and they did so. How did we find this out? We found this out through the course of discovery in the criminal cases that we defended. Pretty scary? Pretty frightening? Absolutely. So this is not the first time that there has been use of right-wing think tanks to gather political intelligence in this country. And why is it purposeful for the intelligence agencies? There's no question that much of what the FBI gets from and the state police gets from these private institutions is garbage from their point of view. But once you keep harping on a particular organization or group, and you initiate an investigation, a federal investigation into Quakers who were protesting the war in 2004, because that's exactly what happened in California, in San Jose, and that's exactly what happened in Chicago. So anti-war groups that were no more a threat to national security than any editorial that might be printed in opposition to the war now became the subject of a federal investigation. So the danger that these groups, these private groups, pose to our First Amendment rights is profound. So what do? I agree to some extent with Mary Catherine Roper when she says that at this point, the courts are not the source of the opposition, or cannot be the endpoint or the resolution of much of what we hear. We defer to the courts as a society. Take it to court, it's a violation of First Amendment rights. It's a violation of my civil rights. We have a court that's packed with apologists for the government. I've said it, I appear in federal court just about every week. And I have wonderful respect and relationship with the federal bench. But the law is very, very clear. The law is on the side of the intelligence gathering agencies. So when the NSA comes forward and says, yes, we violated people's rights, privacy rights, we created a database where we funneled billions of pieces of information with the coordination and the help of private companies, corporations, communications corporations, and nothing happens. And the lawsuits are dismissed, and Congress passes a law saying you can't have a private cause of action seeking damages for violation of your First Amendment rights, for violation of your privacy interests. Where does that leave us? It leaves us with the body politic. So the voice of dissent becomes the voice of protection for our First Amendment rights. That's the bottom line. That's hopefully why you're all here. Excluding those who are gathering intelligence. In Philadelphia, there has long been an active intelligence gathering process. And I know that through the clients that I've represented, and I've represented animal rights activists, I've represented death penalty activists against the death penalty, I've represented anti-war activists, I've represented an individual who was alleged to have been a sympathizer of a terrorist organization, and it turns out that person simply trolled the internet for information about atrocities in another part of the world. So the danger is the label communist in the 1950s is now terrorist. So if you can be labeled a terrorist by a private think tank, and that think tank can push the federal government into an investigation, where does that leave you if you're simply opposing gas drilling in Pennsylvania and the destruction of the pristine wilderness in our state? Where does that leave you? It leaves you on a watch list. It leaves you labeled as a terrorist. It leaves you labeled as someone to be watched and afraid of. And where's the response? The response begins tonight. That's the bottom line. It's in your hands. As a group of individuals that are concerned about our rights and concerned about our freedoms. So I will go to court tomorrow and the next day, and when anyone else gets arrested and is charged with the defense and needs a lawyer that's going to advocate for their First Amendment rights because they've been arrested for exercising them and charged with a criminal offense, I'll be there in court. I want you to be there as well. Not in court, but in a concerted, collective voice in opposition to this encroaching and entrenched culture of intelligence gathering and fear-mongering that's been created in this country and has undermined our democracy. Our democracy is based on not a dead scroll that says you have the right to free speech. It's a dead piece of paper. It has no meaning. It only has meaning in the exercise of those rights every day, all the time. that's what creates the First Amendment in this case. Not the words from a federal judge, not an acquittal in a courtroom when I'm representing peace activists. That's not where we reaffirm the First Amendment. We reaffirm it first with our voices in opposition. Number one, regardless of your political point of view or the issue that you hold so dear, number one, on the right to express it. The war on dissent is unending. The exercise of First Amendment rights is unending. It's not something that's put in a historical box and we think about it. We have to exercise it every day. Don't be afraid. Don't be chilled by the activities of this organization or the state police or the FBI. Be emboldened by the fact that they threatened your privacy interests and your freedom. So I'd ask all of you tonight to think about what you can do in your everyday lives to expand the scope of the First Amendment, of freedom, and not allow these frontiers to be restricted, the frontiers of privacy and thought and communication and print and discussion and dissemination of information, not allow these frontiers to be limited by your fear of being cataloged or identified as a national security threat because some right-wing think tank put you on a list. And in this case, a list of 300 groups and individuals. So that's the quest that we're on. If you believe that freedom in this country is still alive, it's alive and it's in your hands, I'd ask that you exercise it. Thank you.